Welcome back to the Liberty Perspective. I'm Joe Marshall. Intellectual property rights. I got another show for you. I want to kind of pin down a little bit more on how intellectual property rights and the contention between intellectual property rights or property rights, period. Actually, they're going after property, intellectual or intangible property rights, patents, that kind of thing. But what they're really after is all property rights, and in that context of human rights. And the contention between that, and also how the hierarchy of science or the socialized hierarchy of science is coming into play on that, and the whole centralization of science. And they're not, they all come together as one. The centralization of science, the social hierarchy of science, the socialized hierarchy of science, intellectual property rights, human rights, and how the Human Genome Project actually got the ball rolling on a global scale to kind of on a populist world socialist movement to get at that. The Human Genome Project is what galvanized that global world socialist movement against intellectual property rights, against patent rights, and a lot of it because it was the government agencies that were actually submitting patents by the hundreds, if not the thousands, awarding patents. So you got to, but it's government agencies that award patents, but government agencies were actually applying for patents. But overall, what this does is it compromises and eats away at all the property rights, the fundamental property rights of us all, the natural property rights of us all. And without property rights, without an uncompromised right to property, that compromises the ability for a free society to even exist. And they play off the elements of free enterprise, free markets, free market capitalism as the public-private partnership fascism, which they call the capitalism. And they project the elements of a free society, laissez-faire they call it, free enterprise, and property rights. They project the tyranny of what is actually public-private partnership fascism onto the people that are actually subject to market forces. That's what true capitalism is. What true free market forces is the mom and pop shops, the family-owned businesses that are subject to market forces, that have to bring their product out there or their service, and they have to compete on an open market where a free people are voting with their, are voting with their dollars or whatever property they're exchanging on the value of things. So whether it's priceless or worthless is really depending on what the people, free people, think, whether they want it or they don't want it. Now, on the other hand, when you have public-private partnerships, you have extensions of government, subsidies of the government, bringing in windfalls of not being subject to market forces. They're partners with the government that are laying down with the full force of government, dictating who you will do business with or not do business with, or at least discouraging you through high taxes and tariffs or whatever, through the people that they don't want you to do business with, and then along with subsidies and other things of the people that they want you to do business with. So they subsidize their partners while highly taxing the people that are left, that they don't want you to do business with. So that's how they plan an economy. A centrally planned economy comes out of that. It's not a free market. It's not free enterprise. family businesses are the ones, private businesses, companies that are subject to market forces is what true capitalism is. Yeah, Marx came up with capitalism. Oh, come on, Joe. Marx is the one who came up with capitalism anyways, right? So it's got to be bad. Well, what did he call capitalism? What was he referring to when he was calling out capitalism? Free markets, free enterprise, private property, which he said that communism will abolish, along with religions and families, right? That was right out of the Communist Manifesto. But anyways, I'm trying to show you how this assault on intellectual property rights is an assault on all of our property rights, period. And you mix human rights in there, and this is how they're compromising our property rights, is through the world socialism of human rights. Once you understand what your private property rights are through the prism or from the perspective of human rights, then you understand that you don't really have a right to anything. If the planners deem that it's not to the benefit of the collective that you have those rights. That's the difference between our natural individual rights and liberty, our unalienable rights and liberty, versus the conditional human rights, civil rights of human civil origin. But anyways, this is the, I kind of touched on this in my last video, intellectual property and human rights. This is a 1998. This is a 1998 document out of the UN, WIPO, World Intellectual Property Organization, which Dr. David Martin was involved with. This is where I first came across these guys. Was reading his bios, lengthy bios that he had, bragging about doing business with all these guys that he said he never bragged about his own bios, right? But anyways, this is where I first learned about that, and I just kind of wanted to bring this to your attention a little bit to kind of go down over this. And I said this in my last video that I was probably go back and do a whole show on just this document, because it kind of touched a little bit on how the human genome came into play. And in this document alone, the human genome is either mentioned, referenced, or how I put it. It's in which Human Genome Project is either mentioned, cited, and or referenced in the footnotes 21 times. And I'm going to show you a couple other documents too, where the Human Genome Project is central to the next step in the evolution of global governance via the world socialism of human rights. Okay. Now this is again this document right here. Okay. This is I'm just going to go down through it. I got recent. This is a long document. I'm not going to go down through the whole thing, but I got some key points to point out to you to go along that we can kind of discuss and throw out there, and highlight what's actually being said here through from the perspective of the world socialist revolution that's targeted our founding principles, America as founded, our founding republic, our limited constitution, our right and all of our individual rights and liberty, all of our unalienable individual rights and liberty. And unalienable just means that there is no lien no lien can be put on them. Like when you borrow money from the bank for a car, it's not your car. The bank has a lien on it. It's actually the bank's car until you pay the loan off, and you get a lien release. Well, being that our rights and liberty, our natural rights and liberty, as our Declaration of Independence spells out, we had a lien release right from the get-go. The Declaration of Independence is our lien release. It could be seen as that. Yeah, human rights, it's all about they cannot be understood outside the context of the duties owed back to the collective from whence they came. It's the social contract, Rousseau, Hobbes, all the way back to Plato, all say the same shit. The collectivist doctrine, social contract theory, all say the same shit. The duties, you cannot understand any of the rights that you have outside the context of the duties owed to society for them. Because they're human civil rights from human civil origin versus endowed by our Creator, be it nature or nature's God, right? That's the difference. Intellectual property and human rights. The proceeding of a panel discussion organized by the World Intellectual Property Organization, WIPO, in collaboration with the Office of the United Nations High Commission for Human Rights on November 9th, 1998, to commemorate the 50th anniversary of the proclamation of the Universal Declaration of Human Rights. Intellectual property rights are often described as intangible rights. That's what, Dr. David Martin was calling them. The idea behind this classification is that the object of the right is intangible. It's not tangible. It's not a book, or it's not a book that you can hold in your hands. Yeah, these are some pretty cool books that you want to read. The Origin of Family, Private Property and State by Engels, author of the Communist Manifesto, right? Yeah, Frederick Engels. But anyways, it's not tangible. You can't hold it in your hands. Intellectual property rights are often described as intangible rights. The idea behind this classification is that the object of the right is intangible. All property rights placed and the right holder in a juridical relation with others. Let me see. They had an opening address in there. In the opening address... ladies and gentlemen, the right to development and intellectual property require balancing. See, balance, as I pointed out before, is a slave speak word that is put forth in human rights, in the world socialism of human rights, that you, in social contract theory, that you have, there's a balance. There's a balance between your rights and the needs of the collective. That balance being that your rights don't mean shit if the planners deem that they don't mean shit. And the collective always outweighs the individual, if the individual is recognized at all, right? The right to development and intellectual property require balancing the private right of the creator or inventor to protection of his or her intellectual property with the right of the community to enjoy the benefits of such knowledge. And this is where the whole right to science comes in. Right to health, right to repair would fall into that. All these things, all these rights that you have, that is a collective. The right to health is a collective right to health for the collective. The right to science is for the collective. So if you've got people with patents and intellectual property claims on certain things that the collective could benefit from, scientific discoveries, whatnot, that the public could benefit from, that could help sick people get better or whatever, or, is how they put it forth. To benefit that would benefit humanity as a whole, then humanity as a whole has a right to that, and human rights, international human rights, hold the governments of nations, states, whether they signed on to it or not, or agree to it or not. The world socialism of human rights holds every government, national government, responsible for redistributing and making sure that these positive rights, which the government makes sure that these people are given things, whether it's a right to housing, whether it's a right to food, whether it's a right to, recreation, whether it's a right to a job. In prison, they call it a program, which is all basically the same thing here. They're setting society up like a big prison. That's all they're doing. But anyways, there have to be a balance. That's what they're saying. There has to be a balance between the private right of the creator, inventor, with the right of the community to enjoy the benefit of such things. So if you build a better mousetrap, and the mousetrap is going to benefit society, it's really not yours to profit on because it belongs to society. The universality of intellectual property rights, origins, and development. Intellectual property rights are often described as intangible rights. The idea behind the classification is that the object of the right is intangible. Property rights, by their nature, allow the right holder to exclude others from the use of this prime resource so that they are likely to produce instances of rights conflict. They exclude others. If you own anything, it excludes the use from anybody else from using it or having it or owning it. If you have money in your pocket, if you're hoarding money in your bank account, in your savings account, you're excluding others from the benefits that it could bring them. That's collectivist mindset right there. Yeah. To illustrate the point somewhat tersely, I don't know. Property is an expression. Property in expression copyright conflicts. Property in expression conflicts with freedom of expression. I don't know. It's kind of bullshit there. The next section of the paper will, in a brief span, describe the evolution of intellectual property law. The evolution. See, the thing about evolution, you got to remember too, is that intellectual property law, intellectual property from the perspective of human rights, from the perspective of the world socialism of human rights, is that property rights come into being by decree of government. They come from the government. Government gives them to you. That's not a natural property right. But they don't recognize any property rights as natural. They don't recognize any rights as natural. So again, we got to understand that too going into this, just something to keep in the back of your mind there when you're thinking about these things and this intellectual property in science. Compared to a right to science or human rights to the collective on the benefits of whatever that invention that you've got or idea that you've got, whether you're going to be able to, whether it's really yours or belongs to the collective, the balance, right? It says the next section of the paper in a brief span describe the evolution of intellectual property law. The historical focus is on the emergence of intellectual property as part of the positive legal order of states, just like I just said. They come from the state. That's a positive action by the state. They don't exist until the state makes them exist, until the state creates them and gives them to you. Lienable. Of course, you won't be able to understand them outside the context of the duties owed to the collective. Therefore, the balance, whatever that balance is, doesn't matter if it's balanced evenly. There's just the balance. All societies have had to devise norms for regulating the ownership and use of different kinds of information. Historically, this has been especially true of religious information. One can thus identify customary equivalents of intellectual property. But the Western intellectual property tradition is rooted in the idea that intellectual property rights are positive rights. The Western tradition? See, I don't get that, but we see the United States as being Western, right? And the property rights is not a Western tradition that property rights are positive rights created by the state for the benefit of the Commonwealth. That's a pure world socialist, human rights perspective on what, intellectual property rights are. Within the validity of positive law was itself to be judged by the axioms of natural law. The norms of positive law had to converge with the divine design which natural law communicated to men. The rules of positive law then met the test of validity not by being a mere reflection of some metaphysical counterpart, but rather by whether or not they contribute to the overall divine plan. Conceptually speaking, this allowed someone working within the natural law tradition, John Locke, natural law, endowed by our Creator, to recognize the right of the state to modify property rights through the enactment of positive law. Oh, that's just freaking bullshit right there. From our founding principles perspective, it's bullshit. But from a communist, socialist, collectivist, humanist, anarchist, whatever collectivist perspective that you want, from the perspective of the collectivist revolution, from world socialist collectivist revolution, this is what they're projecting. This is what they're putting forth. In contrast to our Declaration of Independence, where our right to life, liberty, and the pursuit of happiness, which requires private property, so that we can have property owned to conduct businesses, which is fundamentally an exchange of property owned for property desired, whatever that service or product, whatever it may, or idea, whatever that might be. It's the exchange of property owned for property desired, through which is the only earthly avenue through which there can possibly be a pursuit of an independent prosperity through which we could use to pursue an independent happiness. Otherwise, you're just sitting there with your hands out, waiting for whatever ration, if you've got one coming at all, is going to come from central planners. If they deem it best, whatever they see benefits the collective, best benefits the collective and the needs of the planners themselves. Good coffee. Anyways, that's what positive law is. It comes from government. They're setting up a contestation between positive law and natural law, and they're actually saying that, well, if you believe in natural law, then you'll understand, and then you will, if you follow natural law, endowed by our Creator, be it nature or nature's God, then you will understand and see that the divine right of governments to be able to compromise whatever right that you have, including the right to property, to best use them the way that they feel they need to use them to benefit the collective, right? And this whole not by being a mere reflection of some metaphysical, because in science, I'm telling you, in science and world socialism of science, there is a implicit and entrenched atheism. It's not just atheism where there is no belief in God. It's an anti-God sentiment. When you say that the collectivist revolution, collectivism in general, you can't understand or put into perspective what the world collectivist revolution is or progressive collectivism is without considering its spiritual aspect, or actually its anti-spiritual aspect, anti-metaphysical, anti-God aspect. It's intrinsic to collectivist doctrine. Read the Human Rights Manifesto. Read the Communist Manifesto. I mean, there are Bible communism communes that have been established. Noyes was one of the ones in Transcendentalist Bible communists in Oneida, New York, not too far from here, back in the 1800s, that have set these things up. But then there's Walter Rauschenbusch's Socializing the Christian Order. I did a show on that, actually, on how Christianity was actually being used to implement the secular anti-God aspects of world socialism, of world collectivism. It's nuts. You should read it. You should watch that show. Look it up. I think it's Back to the Basics. Walter Rauschenbusch's Socializing the Christian Order. But anyways, it gives you an idea how the Christian churches and other religions as well have been utilized to basically push the anti-Christian realities of collectivism. It's crazy. But so the next where were we? Okay. Right. During the 1980s, the USA reshaped its trade law to give it a series of bilateral enforcement strategies against countries that it considered had inadequate levels of intellectual property enforcement or which were weak on the enforcement of such rights. Yeah, the USA, the American, capitalism is going to be put out there, property rights, intellectual property rights. America is going to put forth that individualism of property rights, individual rights and liberty, actual free society freedom shit, and the central planners of world socialist revolution, they're going to despise that. On 15th of April 1994, the Uruguay round included the Marrakech, I don't know how to say that, with a signing of the final act embodying the results of the Uruguay round of multilateral trade negotiations. More than 100 countries signed the final act. It contained a number of agreements, including agreements establishing the World Trade Organization and the TRIPS agreement. This TRIPS agreement will come up again and again and again through human rights doctrine, through intellectual property rights documentations or whatever. It just keeps coming up and up and up and over and over and over. What that was like, this United States actually trying to, when we're and our trading partners across the world, we want that our patents and intellectual property rights recognized. We don't want people all over the world just willy-nilly taking these things over and benefit for themselves when they should belong to the people who came up with them and to whom they belong, right? Yeah. The TRIPS agreement was made binding on all members of the World Trade Organization, where there was no way for a state that wished to become or remain a member of the multilateral trading regime to sidestep the TRIPS agreement and to sidestep the recognition of intellectual property rights and patents. The TRIPS agreement marks the beginning of the global property epic. And it's the United States' fault, right? The TRIPS agreement is built on the edifice of the principle of territoriality. The TRIPS agreement is built on the edifice of the principles of territoriality and national treatment, but it also represents the beginning of property globalization. Like I told you, this is globalization in collectivist doctrine and world socialist doctrine. World socialist intellectual property doctrine. Globalization is just another, mostly it pertains to, as a rule of thumb, it pertains to the spread of capitalism throughout the world, the spread of property rights, an individualism type of rugged individualism, free enterprise, and recognized property rights in a free society. It's the spread of that around the world, which, of course, world socialist, collectivist, and the world socialism of people advocating the world socialism of human rights, they're going to detest that shit. They don't want that out there. We want a centrally planned everything. We want a global governance. But I'm not saying that everything was good or everything was perfect in our agreements going across with countries, but they're not attacking those specific agreements. They're attacking the system, the regime, if you will, of intellectual property rights. That word regime will actually come back up again here in a minute to put it in a little bit better context from what I just said. So the TRIPS agreement, United States is actually trying to enforce the recognition of private property and intellectual property rights with our trading partners. And they're complaining that if you want to be the trading partner of the United States, there's no way for you to sidestep this shit. Human rights, the right of property and intellectual property. This section looks briefly at the extent to which intellectual property rights have been recognized in the human rights regime. To which intellectual property rights have been recognized in the human rights regime. So there's regime. There's the human rights regime, the world socialism of human rights regime, and then there's the rugged individualism and free enterprise of the intellectual property regimes now, right? The following two sections then explore the relationship between intellectual property rights and human rights. That contention, that conflict that's there. I'm not making this shit up. I'm just trying to show you in an actual United Nations WIPO document, World Intellectual Property Organization document, that this contention is there. And it doesn't pertain just to these intellectual property rights. It pertains to property rights, period. The contention is there for any rights, any natural individual rights, period. Not just all property rights, but all rights. And all rights that enable your right to pursuit of happiness, an individual endowed by your Creator right to the pursuit of happiness, an independent happiness. Thinking about the right of property in the context of human rights reveals nicely the paradox of property. Paradox of property. I think Malone says paradoxical. Like, I don't know. Every time I hear him, he's always using the word paradoxical. Thinking about right of property in the context of human rights reveals nicely the paradox of property. When a general right of property is recognized in a human rights instrument, it is made subject to some sweeping public interest qualifications. Exactly. The balance. Your right to property. And they're not talking about intellectual property rights. I'll read that again. Thinking about right of property in the context of human rights reveals nicely the paradox of property when a general right of property is recognized in human rights instrument. It's not just intellectual property rights. It's not just intangible property rights. It's not just patents. They're targeting the general right of property, the general recognition of property, period. When the general right of property is recognized in a human rights instrument, it is made subject to some sweeping public interest qualifications. That's on page 26 of that document. It's right there. Intellectual property and the right to health. See, we have there's going to be a right to science. There's going to be a right to health. There's going to be all these recognitions of all these intellectual property rights, or recognition of property rights, period. I mean, how can they confiscate 30, 40, 50, 60, 70, 80, 90% of your income for redistribution of wealth, depending on what country you're in? Right, or have been in. Socialist countries have been known to freaking confiscate 80 or 90% of the income of people in order for redistribution, but they can't confiscate and redistribute to confiscate property for redistribution if it isn't their property to confiscate. So their right to property has been confiscated by anywhere from 30, 40 to 80 or 90%. How are you supposed to be able to maintain a way of exchanging property owned for property desired when 30, 40, 50 to 80 or 90% of your property to be able to do that, to conduct business with, is being confiscated for you for redistribution of wealth according to the needs of the planners, the rulers, the masters of society. So you got intellectual property and the right to health. I just want to go down through here a little bit here. I don't want to read everything, but anyways, this paper deals with the subject of the various relations existing between intellectual property and the right to health. Same shit, right? References will be made within an industrial property system, especially to patents, as a crucial instrument in the development of the pharmaceutical industry, which in turn has afforded the world's population greater and better access to health systems. Clear though the above premise is, it is also fair to say that the subject of the protection of pharmaceuticals, and especially drugs that by means of intellectual property rights, has given rise to major discussions on the world stage. Here we go, right? We therefore move on to deal with another subject that is closely related but still relevant, and which has given rise to discussions in industrialized as well as less developed countries concerning access to biological resources. Access to biological resources. Access to genetic resources is a subject that has come under discussion relatively recently and has become important as to the search for new drugs, new therapies, new cures in the planet's biodiversity has intensified. The search for curative substances in nature is nothing new. So, going out into the jungle to find all these plants, the biodiversity of nature and the wilderness, and in the knowledge of indigenous peoples and stuff, there was a big push for that. And there's probably still a big push for it to some degree. But I remember them being a big push for that. And of course, they want to go right to the jungles and access indigenous people's knowledge on what plants they're using for this medicine or that medicine. And they can go out and they can take all these sources from nature, take them back to the lab and derive different things out of them to see if they can use them for, making modern medicines or whatever, right? There's a conflict in that, because the countries that they're going into to obtain these resources are then they're taken back by the pharmaceuticals and whatnot, and then they're creating patents on stuff that the people can't afford, where the pharmaceuticals are getting these natural resources from. So wait a minute. So hold up. Oh, where's mines? You know what I mean? Right. This interest has at the same time aroused controversy regarding the possibility of intellectual property rights being improperly asserted in order to appropriate the products of biological diversity without corresponding compensation for the country, area, tribe, or ethnic group that provides the biological resource or raw materials for its development. Like I said, where's mines? Get yours, where's mine, right? Debate has thus focused on the need, assuming the possibility of patents being obtainable for natural products. Patents for natural products. How does that even come in? How can you get a patent if I go out and I find a bush in the hedgerow or something? I want a patent on this. Or if I pick a pear or pick an apple and I like the way this apple is, and it's a natural product. You can't put a patent on nature, can you? I don't know. It's a question that's kind of being thrown out there. Yeah. So assuming the possibility of patents being obtainable for natural products, this is going to come back too. With the exclusive rights that they bring, for there also to be the possibility of recognition and due economic compensation for the person or persons who provide the raw materials. And this is just my note in red here, is they want in. They want their cut at the expense of property rights of all. At the expense of property rights for all. They're trying to get their cut for them. Now, all you got to do, if you have a natural resource, I don't care if it's coal, I don't care if it's oil, I don't care if it's whatever mineral or even water that's part of your property or, located on your property. If it's a plant or if it's a state-owned property, then the government that owns that property in another country or whatever, you make the deal. We have access. If we get access to you, we'll cut you in. We'll pay you. How much would you charge us to come in there and get this stuff, whatever, just to see if it's going to work? Because we don't know if it's going to work. Make the deal. Make the deal. But now they're saying just like somebody just went in there, paratrooped in the middle of the night and just kind of cut a bunch of plants and took plants off or whatever, took specimens, and just like a thief in the night, right? And now they're going to profit on it. Well, how did these people get in there? Who gave them permission to go in there to get these samples? And why didn't they make a deal then? I don't know. Just a question. But you see the conflict, the contention that's there, that they're putting forth. Another major subject that arises when the issue of relations between intellectual property and the right to health is introduced is in bioethics. Boy, that was something that I was going to put on here and didn't. Introduced as bioethics. Remember, bioethics is the same field from which Pete Singer and other intellectuals, all right, have put forth that it's moral to have sex. Pedophilia and bestiality would be moral. It's the same bioethics. Just remember that. Yeah, another major subject that arises when the issue of relations between intellectual property rights and the right to health is introduced is bioethics. Bestiality, pedophilia. Look up Pete Singer. I'm not making this shit up. It is a subject that has also been seriously debated worldwide in connection with the possibility of using intellectual property to secure exclusive rights in human body parts. Well, they're assuming the possibility of natural patents on natural products up here, and now they're worried about if you're going to have a property right on natural products, that would include body parts or body sequences, right? Which is kind of nuts. But how can they complain about one, not the other? I don't get it. Yeah, this debate came into the open above all with the implementation of the Human Genome Project, whereby all human genes are to be sequenced with a view to treating a number of diseases by means of gene or genetic therapy. So all this contention is what I'm saying. This whole push the debate came into the open above all with the implementation of the Human Genome Project. It's the Human Genome Project got this ball rolling. This whole assault against intellectual property rights in general, which was the whole debate was even started with why would you want to patent genetic segments, genetic parts, willy-nilly here of the human body. How can you do that ethically or morally? Depends on what your ethics and morals are, right? Bioethics, right? But anyways, yeah, whereby all human genes are to be sequenced with a review treating a number of diseases by means of gene or genetic therapy. The legal, ethical, philosophical, and religious implications, so now they're going to use religion. They're going to throw religion in there because the enemy of my enemy is my friend, right? Of such a project and of the idea of partnering or patenting parts of the human body has aroused protests on the part of various groups, and it is still uncertain just what the repercussions will be for the development of society. I'm not worried about you. What's the repercussions in the development of society? Are we going to go through some kind of technocracy? Whatever the collectivism is, it's all centrally planned. It doesn't matter. Can't have a collectivist society without it being a centrally planned society. Top down. This paper, therefore, aims to take a broad sweeping look at the patenting of pharmaceuticals and the controversy that has risen between developing and developed countries on the subject, and to show how that controversy was brought to an end in an international treaty that will then consider the subject of access to biological resources as a source of raw materials for the development of new drugs. The first part will thus deal with subjects like the patent system, the pros and cons in the patenting pharmaceutical products, the relevant provisions of the TRIPS agreement, remember, where America is trying to force the recognition of property rights on the world, and the globalization that America wants to spread, right? In the matter of parallel imports and the exhaustion of intellectual property rights. The exhaustion of intellectual property rights, the latter two being still contentious at the world level. They want to, the matter of parallel imports and the exhaustion of intellectual property rights, the latter two being still contentious at the world level. Yeah. I mean, this was back in 98 when human rights weren't really, I mean, they were out there, they were being talked about and stuff. People referred to our fundamental human rights and started confusing our fundamental human rights with our actual, endowed by our Creator, individual rights and liberty. Started confusing the two when they're diabolical opposites. They're matter and antimatter. So the more people that confused them, the more people that would allow the trespass of those human rights onto what our actual individual rights and liberty were. So we start defining what our actual individual rights and liberty are, our founding principles are in the context of these human rights. The more we confuse the two, the more that can happen, right? The more that confusion, convolution, and confusion can happen. And ultimate chaos out of confusion. I'm just showing you what these papers are out there. This stuff has been out there for a long time. I've been trying to tell people about this stuff for a long time, and how the human rights, the world socialism and human rights has targeted our whole free society for destruction, has targeted America as founded in our founding principles and our whole constitutional republic for destruction. And, you know, there's people in our government agencies that are on board with this shit. More and more and more as time goes by. Back in the 90s, not so much yet. Even though progressives and the progressive era even started back in the late 1800s or mid 1800s, actually early 1800s, if you want to count the transcendentalist movement as part of the progressive era. You know, the progressives all through the 1970s, 60s, 70s, that were all pushing our country away from our individualist foundings towards the collectivism and the world socialism of human rights. You know, the New Deal, the establishment of the Universal Declaration of Human Rights at the UN, being pushed by one of our own first ladies, Eleanor Roosevelt. All right. So this revolution has been taking steps towards the realization of the destruction of our republic and our individual rights for a long time now, going on 200 years. 200 years. Yeah. Finally, a third part will deal with the subject of bioethics. There's your bioethics again. with special reference to the Human Genome Project and the United Nations Educational, which is UNESCO, Declaration on Human Genome and Human Rights. Yeah, the UNESCO's Declaration on the Human Genome and Human Rights. Yeah, they put one of these out. There it is right there. Universal Declaration on the Human Genome and Human Rights. Right there. Yeah, it says this came out in 2001 or 2002. The Human Genome Project has been defined as an effort to compile information on the genetic and physical features of the human genome, to map its DNA sequence, and to understand the interactions between human genes. Yeah, the Universal Declaration of Human Genome and Human Rights was adopted on November 11th, 1997 by UNESCO General Conference. Yep. Yeah, and prior to that, the international level, various provisions existed in several international instruments referring to the rights and obligations with regard to the protection of human dignity. There's that word dignity and human rights again. In the area of scientific research. Article 25 of the Universal Declaration of Human Rights, a legally binding document, provides that everyone shall have the right and standard of living, has the right to a standard of living adequate for health and well-being for himself and his family, including food, clothing, housing, and medical care and necessary social services, the right to security in the event of unemployment, sickness, disability, widowhood, old age, and other lack of livelihood in circumstances beyond his control. Yeah, all those. Food, clothing, housing, medical care, necessary social services, and the right to security. All rights of prisoners, by the way. Just so you see it. Just so you see it. But, again, the ball got rolling, and this is all in reaction to the Human Genome Project. It's all in reaction to the Human Genome Project. This is what I'm trying to. This is what I'm trying to show you. Now we get into the right to health. Now you have the right to health is provided in Article 25 of the Universal Declaration of Human Rights. Okay, just like we just said. Within that set of variables, access to drugs and techniques for therapeutic diagnosis, and also access to sophisticated apparatus for diagnosis, prevention, and cure of disease become essential factors guaranteeing the health of human beings and humanity. The patent system. The legal literature has divided intellectual property, the overall generic term, and created two subfields called copyright and industrial property. Copyright has served to protect the manifestations of intelligence and art, and above all creations in the sphere of what is aesthetically pleasing. The important thing about this subfield is that copyright protects the concepts or the forms of expressions of the ideas, but not the ideas themselves. Patents originated with the Venetian Decree of 1474 and the British Statute of Monopolies. That's where they say patents originate. Now, we could mention among the precursors of modern industrial property law, the 1778 Constitution of the United States of America, which allowed Congress to grant, see that? This is the world socialism of human rights, telling you what our Constitution says. The 1778 Constitution of the United States of America, which allowed Congress to grant. Now, this is word for word what frickin' Dr. David Martin, pretty much word for word, what Dr. Martin was saying to Shannon Joy on the Shannon Joy show, which she didn't even push back on. She never even pushed back on it. Didn't catch it. I don't think, as long as they're getting ratings, right? Didn't catch it. But this is where we are. This is what they're saying our Constitution says. The 1778 Constitution of the United States of America, which allowed Congress to grant authors and inventors exclusive rights, in their words, in their works and inventions for a specific period, and for which in turn emerged the 1790 Patent Act. One could also mention the French law, 1779, which recognizes inventors as a sacred and inviolable property right. Now that we have established where our present patent system comes from, which is bullshit, this is how they see where the patent system comes from. It is interesting to take a look at their particular characteristics. It has also been mentioned that patents are titles conferred by the state, so that the rights actually represent recognition by the state. They do not legally come into being until such time as the state has caused them to be recognized by means of a procedure laid down in its legislation, which is positive right. Therefore, that's what makes it a positive right. So if it's a positive right created by the state, it's under the conditions made by the state. To be recognized under the conditions made by the state. Under the lien provided by the state. In other words, they're positive rights. But there's a problem with this whole thing right here, and I don't know, maybe I'll get into it in some other place here. Our Constitution does not grant, our Congress doesn't allow Congress to grant authors, inventors exclusive rights to their works and inventions. It ordains Congress the power to secure those rights on behalf of those inventors. They're natural, unalienable rights already that preceded government. And I went over this on another one of my shows too. It's the world socialism is saying that the government grants these rights. Dr. David Martin said that the Constitution says our Congress grants these rights. Matter of fact, Martin said it's the only right guaranteed to us and granted to us by our Constitution. That's what he said. Okay, maybe that'll come up again, I don't know. Access to biological resources. Here we get into that access to biological resources again. In the U.S., the Patent and Trademark Office traditionally considered natural products and living organisms to be the products of nature and therefore not patentable. Here's where we get into some crazy shit about where all of virology actually stands today. Right? So, the Patent and Trademark Office traditionally considered natural products and living organisms to be products of nature and therefore not patentable. The only exception made to that rule was when certain patents were granted to Louis Pasteur. Nevertheless, the Court of Appeals ruled in a 1977 case that even though natural products per se could not be patented, it was possible to acquire protection for any new form or composition. So, if man were capable of isolating a natural element that did not exist as such in nature, and of giving it a function, that element was patentable. This was back in 1998, they're talking here, but the ruling was in 1977. I'm going to read that to you again. Now, just think about how they're actually, on how, you get a sequence out of a mud puddle. And Dr. Jonathan Cooey has talked about this on his show, Gigaome Biological. He talks about this and what virology has become. Yeah. The court ruled that even though natural products were per se could not be patented, it was possible to acquire protection for any new form of composition. So if a man, quote, if a man were capable of isolating a natural element that did not exist as such in nature, which is what they do to the sequence they find in a mud puddle, they take it back to the lab, and then they create the synthetic DNA, the recombinant DNA, right? They fabricate it. They make it so that it can spread, that it can make people sick. They give it. That's where your gain of function is. It's not from the virus to a super virus. It's from a benign sequence in a mud puddle to the claim of that this is the virus that's going to spread. It's a fabric. I don't know, but now they can patent that. And that's what isolation is. We're capable of isolating a natural element that did not exist in such as nature, and of giving it a function. And that's what they do. They'll take the DNA. I'm just their RNA sequence that they find in a mud puddle, and they take it back and they purify it and make a bunch of synthetic clones out of it, right? And then they manipulate it to the point where they give it a function. Now it's patentable. Now they can put a patent on it. Now all they need now is a loss of function mouse that's been genetically manipulated to the point where it's super compromised, super susceptible to this new recombinant, fabricated, synthetic, patentable sequence or whatever pathogen now that they've created in this lab out of the sequence in the mud puddle, and they gave it a function, right? Now they can inject it into a mouse or a rat that's been genetically manipulated to be super susceptible to that function that they gave that synthetic sequence, and say that this is what's going to happen in nature, and why we got to lock society down, why we got to forcibly, force everybody into these, vaccines and whatever countermeasures that they want to enforce society onto, lock everybody down. And this is what they base everything on. I don't know. I'm just a landscaper. But, it's right there. Yeah, so if a man were capable of isolating a natural element that did not exist as such in nature and of giving it a function, I've gone over this in other shows, that element was patentable. This stance led to the acceptance of purified natural products as being new and patentable. And you got to remember, it's the Human Genome Project that got the ball rolling on this, right? From that decision onward, patents began to be granted for living organisms. In 1980, the Supreme Court ruled that the celebrated diamond, whatever case that is, that a patent should be granted for the first genetically modified bacterium capable of cleaning up oil slicks. The court ruled that a living man-made microorganism had to be protected under legislation of USA as a product or composition of matter. That decision gave the USA Patent and Trademark Office a legal framework within which to grant patents both for plants and for non-human animals. It is worth mentioning that this decision refers to a utility patent concept, in contrast to the patent concept of the Plant Patent Act, which was mentioned at the beginning of this subsection. In 1985, a patent was granted for a variety of maize, You call it maize, we call it corn. You call it corn, we call it maize, remember? That contained an increased level of the amino acid tryptophan, whatever. And in 1998, the first patent was granted for a genetically altered animal, namely a rat, that was given a uniform susceptibility to cancer. This is the frickin' genetically manipulated animal, rat or mouse. What do they call them? Knockout mouse? I don't know. They knock something out of it so they make it susceptible, right? I don't know. This is where the biology of Dr. Jonathan Cooey comes in, because I'm just pointing it out in social contract theory, where all this shit is. He's got the biology. The two are connected. They're not different. As he says, it's all the same show. It's all the same revolution. It's all the same collectivism. Is what I'm trying to say. The first patent in 1988, the first patent was granted for a genetically altered animal, namely a rat, that was given, is that the knockout rat? I don't know. Was given a uniform susceptibility to cancer. So they take the genetically altered sequence, purify it, which is isolating it, I guess, and creating synthetic version of it is isolating it, but then they give it a function, and then they inject that function. Was that a transfection? I don't know. They inject that function into that genetically manipulated, genetically compromised rat or mouse, in this susceptible to that. Well, okay, this sequence causes cancer. This sequence causes, COVID. Whatever they want to do. Okay, it was a rat was given a uniform susceptibility to cancer, which made it an excellent instrument for research on possible cures for the disease. The situation in the USA has evolved to such an extent that even human genetic material has since been patented. It is now possible that the country to patent genes. It is now possible that the country to patent genes, their location, the means of locating them, gene techniques, cloning techniques, diagnostic probes, etc. The situation in the United States has evolved to such an extent that even human genetic materials has been patented. It is now possible in that country, in America, to patent genes, their location, the gene's location, the means of locating them, the gene techniques, cloning techniques, diagnostic probes, etc. So they've patented every single process through which they're doing. Because it's the first time it's been done. They're patenting all this shit. If they were doing it all with their own money and under their own expense, it would be one thing. But the Human Genome Project is a publicly funded, owned and operated operation. As is what percentage of the science out there, what science, what labs are doing work on these, what labs are isolating allegedly natural sequences without public funding. What labs are doing this? What labs are doing this? That are isolating natural elements that did not exist as such in nature and are giving them function so that they can be patentable. What labs are doing that? So with their own money, out of their own pocket. Not funded by a government or any government subsidy or any government partner. Right. Well, one can describe the foregoing as progress The legal protection of living organisms has been the subject of much discussion. It involves ethical, philosophical, religious, and political considerations, and these have fueled the debate on whether or not it is right to protect inventions of this kind by means of intellectual property rights. For instance, the small number of patents that have been granted for plants and animals in the European Union have been officially opposed by a number of organizations. More than 80 non-governmental organizations collectively filed a legal objection to the grant of the patent on the oncorat. The genetically modified rat. Is that a knockout rat? I don't know. But there you have the oncorat. They genetically alter it so that it's susceptible to the synthetic biology that they've created. And then they can create all kinds of scenarios, run it through their modeling, and present it to the planners, and get all kinds of funding to continue doing this work, which give the planners more power, because then they can take that scenario, right, and use it for whatever purpose that they want, nefarious or not. But that's where science is today. We shall consider this subject in greater detail in the section on bioethics. Remember bioethics. Traditionally, biodiversity was considered a resource of mankind. This is right in John Locke. This is right out of John Locke here. This conception gave it a status of a common inheritance or an heritage, although, in fact, because it belonged to the human race, it belonged to everyone and no one. It didn't belong to the human race. It was just a state of nature. It's in a state of nature. Nature didn't belong to humanity. It's God's creation, according to John Locke, where our founding principles were derived, right? But you got to remember, we're reading this from the perspective of the world socialism of human rights, or just the human rights aspect of world socialism. It belonged to everyone and no one, and anyone could make use of it. So free access to the biological resources and germplasm was the order of the day. It is well known that the geographical distribution of biodiversity is very uneven, and it often happens that it is concentrated in less developed countries with little territorial scope and limited resources and developed potential. It has not been said lightly that the countries of the third world possess green wealth, which has also been called green oil or green gold. This is right back to that same contention that we talked about earlier, right? This is what makes for the great ironies where product development with extractions originating in a specific country on being transformed in a laboratory in industrialized countries becomes commercially valuable goods that are sold and distributed throughout the world, passing through the hands of transnational companies without the country of origin deriving any benefit from the exercise. So why only? This is me in red here, just a note here. So why haven't they treated them like any other mineral right and charged lease or otherwise contract for their access? That was, I don't know. But if you just abolish property rights altogether everywhere, then the central planners and the global governance central planners can just mandate a redistribution of wealth and maintain that communist lawn throughout the world, because a communist lawn isn't fully established until every blade of grass is mowed to the same height. The redistribution of wealth has to come down to the same level. The third world come up, and then all blades of grass, all the countries in the world are mowed to the same height. It kind of gives you a picture of what they're looking for. So the fact that all countries have cost-free, unrestricted access to the natural resources of another country without the latter being given credit for its contribution as a provider of the biological resources is inexplicable, but nonetheless a fact. By whose fault? How'd they get access? Again, like I said, why didn't they contract for the shit? That's all they got to do. Like many others in the world, the wide-ranging discussions that have taken place on the subject throughout the world, together with some regulations of the resolutions on the Food and Agricultural Organization on its repercussions in agriculture, provided background to what was negotiated and settled in 1992 United Nations Conference on Environment and Development in Rio de Janeiro, the result of which was the signature of 157 countries. The signature of this convention stirred up great controversy and confrontation between developed countries and the third world, owing to the fact that its proposals radically altered the picture described earlier. Briefly, as far as our subject is concerned, the Rio Convention was a reaffirmation of the value of genetic resources for the future of mankind and the sovereign right of every state to its biological diversity. Clearly, it has caused a complete break with the established scheme of things, in the sense that biological diversity has ceased to be freely accessible and is now a resource specific to each country. Isn't that what they wanted? So they're complaining from both sides of the same coin. They're complaining about both sides of the same coin. What the fuck? What the fuck? They want it all. They want it both ways. We can't have a nationalized biodiversity. It must be under the centralized control of world socialist, redistributive, human rights-based global sovereignty. Yeah, see it. Global governance. Human rights-based global governance. Yeah. The conclusion was reached that in any event, the forests were being ruined by clandestine tapping of their biological resources. It was better that it be done in a sustainable way. Bioethics. Here we get into the bioethics a little bit. Knowledge of the human genome added to the possibility of isolating human genes. The knowledge of the human genome added to the possibility of isolating human genes, so that they can patent them. They make some synthetic ones so they can patent them, which came about in 1977, and the possibility of genetic manipulation of organisms aroused great scientific interest in this field, with the opportunities that it offered for preventing and curing diseases that until then had been difficult to eradicate from the human race. All this gave its importance to the Human Genome Project, which started in the USA in 1990 and has since been endorsed by a large number of countries around the world. The main objective of the Human Genome Project is the identification of the approximately 80,000 genes that constitute human DNA. Is it still 80,000? I mean, this was back in 98, right? And the working out of the sequence of 3 billion chemical bases that form it, their incorporation in databases, and the development of instruments to analyze them. The project was originally calculated to last for some 15 years, but it was announced recently that special equipment could be used to reduce that time considerably. Its cost has been put at $3 billion. I've seen where it's double that. It's financed for the most part with U.S. government funds and is overseen by U.S. Office Research and Environmental Health and Energy Department and by the National Genome Research Center and the country's National Institute of Health. Without claiming to encompass all questions asked, it could be said that the main concerns have ranged from the religious viewpoint, according to which man has no right to manipulate life, that being God's preserve, to more down-to-earth questions, the negative connotations on the religious aspect there. See it. To the more down-to-earth questions, such as, will the development of a super race be possible? Will mankind once again experience the horrors of the Nazi era? How is genetic information to be dealt with? Should a person be told his or her organism is predisposed to contract a particular disease? Could an insurance company refuse insurance on the basis of genetic information? Can a genetic explanation be demanded prior to marriage? Well, they used to have blood tests. I remember when people had to get a blood test before they got married. I think it was more like Rh negative or Rh positive. But who decides what is good or bad? How far should science go? Well, the central planners want control of that, right? Not the willy-nilly individualist way of free enterprise. I don't know. Bioethics has had to deal with the argument stirred up by the possibility of patenting genes on the other parts, components, and other parts and components of the human body. As we said in earlier photographs, by dint of a very broad interpretation of USA laws on the isolation and function of products found in nature, back to that, right? Isolating again, and recombinant DNA and the synthetic DNA and synthetic virology, right? It has become possible that in that country to patent isolated genes, therapies, cloning techniques, cell lines, and ex vivo gene therapies that include human cells, among other things, and more recent sequences of human genetic material. More recently, sequences of human genetic material. By the beginning of the 1990s, the USA National Institute of Health were already embroiled in controversy arising from its plan to patent so-called expressed sequence tags, fragments of DNA that represent the expression of genes without identifying the gene. So that while it is known that the genes are from a human body, it is not known actually what gene is involved or what its function is. The scandal reached such proportions that the NIH abandoned their plan, and indeed, director at the time was forced to resign. In spite of the controversy, the UN Patent and Trademark Office subsequently announced that it had granted the patents to private companies. The magazine Nature reported that during the period between 1991 and 1995, 1,175 patents were granted to 300 organizations for human gene sequences, with an average of 3 sequences per patent, many of them in Europe and in the United States, but all originating in North America and above all Japan. With regard to the Human Genome Project, a team of scientists working on it, grouped in an organization known by the acronym HUGO. How many people are aware of that? The team of scientists working on it, grouped in an organization known as the acronym HUGO, aka the UN of Human Genome, has expressed special concern that the project should be governed by bioethical principles. Bioethical principles, again, bioethics. The same bioethics. From which, the same secular bioethics, from which Pete Singer's morality of, pedophilia and bestiality. I don't know. And other intellectuals. Elites. Yeah. But anyways, there we are. With regard to the Human Genome Project, the team of scientists working on it, grouped in an organization known by the acronym HUGO. I'm going to get into this HUGO in a minute. I got a little asterisk right there. Notification for, we'll get into who that organization, what that organization is and who they are in a minute. They have expressed special concern about the project should be governed by bioethical principles. That means that the consent of the patient to the taking of samples will be crucial. Yeah. It means that the consent of the patient to the taking of samples will be crucial, and as for information produced, most of the public will be guaranteed access to it. Most of the public will be guaranteed access to it. As far as patenting is concerned, the main worry of the members of HUGO is that the patent granted may prevent them from achieving their objective of mapping the human genome. It gets in the way of things, slowing shit down. In a public statement, Hugo expressed concern that the partial patenting of DNA sequences without identification would benefit the scientists who made the routine discoveries, but penalize those who have ascertained biological function or application. A strategy of that type would hamper the development of therapeutic and diagnostic methods, which was clearly not in the public interest. For their part, they promised early disclosure of information on the genome with a view to speeding up its dissemination and thereby promoting research on the functional aspect of genes. It can thus be seen that the key discussion in this case has to do with the lack of functionality at the time of the patenting the gene, sequence, or cell line. That has been one of the severest criticisms of many of the patents that have been granted, as it amounts to obviating, or more accurately, broadening the criterion of industrial application or usefulness of the invention. It was precisely in response to that urge. It was precisely in response to an urge to intervene in this discussion, and with a view to establishing firm foundations for these ethical considerations, that the United Nations, mainly through one of its agencies, UNESCO, has for a number of years been working on a declaration that aims to reinsure the rights and liberties of every individual within a society in the event of action on the human genome. Yeah, UNESCO's going to be looking out for you. UNESCO. We got UNESCO looking out for us, right? But anyways, I want to go over what this Hugo is, because this is just something I stumbled on. I said, you know what? I'm going to check out what this Hugo is, AKA the UN of the human genome. There it is. Hugo, a UN for the human genome. I ain't making this shit up, For more regarding Hugo and the role of the Human Genome Project in the centralized codification, implementation of the world socialism of human rights into not only genomics, but the whole of science and public health. See this, scripted. It's just a coincidence that they're called scripted, right? The significance of UNESCO's Universal Declaration on Human Genome and Human Rights. There it is. The significance of UNESCO's Universal Declaration on Human Genome and Human Rights. Yeah. And I got just a couple things on page 22 to 23. Genetic research, knowledge, and the distribution of new genetic biotechnologies are facilitated by a world in the throes of globalization. The distribution of new genetic biotechnologies are facilitated by a world in the throes of globalization. So capitalism, the spread of capitalism and property rights, and America's non-compliance to global governance, I guess. I don't know. Which contributed to concerns about the Human Genome Project and the worldwide implications of its potential negative consequences. Some concerns were expressed as follows. The interdependence of development in the world is felt more acutely today than ever before. The Human Genome Project, which will lead to breakthroughs in most intimate knowledge and biology of human beings, requires true international cooperation and an unrestricted exchange of information. Firstly, because of the returns that this can have in relation to research and application, and secondly, because the need for international analysis of the societal, ethical, and legal implementations of this project could engender. Yeah, the Human Genome Project, again, being listed as instrumental in igniting this whole movement and justifying in justifying the whole assault on property rights, intellectual property rights being the spear point, but as we saw and have seen, it encompasses all of property rights, which then encompasses all of our natural individual rights and liberty. Because property rights, as I've gone over before and shown before, as one of our founding fathers, Noah Webster, put it, property is the fountain from which the stream of liberty flows. It's not the stream of liberty, it's the fountain from which the stream of liberty flows, and that property is where our freedom is to be protected. Protect property, we protect our freedom. And this is what I'm trying to put out there, trying to show you. This led UNESCO to conclude effective legal and ethical responses would have to be coordinated globally, okay, against this globalization of set into motion by the United States and the Genome Project, right? To conclude that effectively legal and ethical response would have to be coordinated globally, an international initiative reliant on universal standards derived largely from the International Bill of Rights, which includes the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economical, Social, and Cultural Rights, could be coordinated through UNESCO. Thus, in 1993, UNESCO's newly created International Bioethical Committee began drafting an international bioethics instrument specifically directed at human rights and genetics. Now, remember, this is coming from so we're going back here against this globalization, the human genome, in the context of the Human Genome Project. UNESCO, they're advocating all this world socialism right down through here. Now, all these things together, it's not just the Universal Declaration of Human Rights that is holding this to it, because as you'll see, the Declaration of Human Rights, it goes back, that wasn't really enforceable until it was included along with these other things. Now, universally together, they hold nation states responsible. They hold nation states accountable. Binding. It becomes binding. The UN Declaration of Human Rights becomes binding in the context of all these other things that were just mentioned here. Yeah. Universal standards derived largely from the International Bill of Rights, which includes, this International Bill of Rights is what makes it binding, which includes the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economical, Social, and Cultural Rights, the ICE, SCR, could be coordinated through UNESCO. Thus, in 1993, UNESCO's newly created International Bioethics Committee began drafting an international bioethics instrument specifically directed at the human rights and genetics. Now we get into what the Human Variome Project, I don't know if anybody's heard of this, is another aspect of it. The Human Variome Project was an NGO maintaining operational relations in the United Nations Educational, Scientific, and Cultural Organization, UNESCO, about the Human Variome Project. It's an international non-governmental organization that is working to ensure that all information on genetic variation and its effect on human health can be collected, curated, interpreted, and shared freely and openly. Okay, this is what the Human Variome Project is. The Human Variome Project provides a central coordinating function for national and international efforts to integrate the collection I can get this here better to see it. Yeah. The Human Variome project provides a central coordinating function for the national and international effort to integrate the collection, curation, interpretation, and sharing of information on variation in the human genome into routine clinical practice and research. I've heard Cooey mentioned this before, Dr. Cooey, on how the genetics, they're sampling genetics, all these PCR tests and everything else, everything's collectible genetic evidence. They're samples. They're being used, right? And this is what the Human Variome Project is doing here, is it provides a central coordinating function for national and international efforts to integrate the collection, curation, and interpretation of and variation of the human genome into routine clinical practice and research. That's UNESCO. You can't see it, but there's UNESCO logo right there. Oh, sorry about that. Now that link isn't taking me to where I want it to go, but you have to look it up. I guess. We are an active and growing consortium of over 1,100 individual researchers, healthcare professionals, policymakers, and organizations from 81 countries that collaborate to develop and maintain the necessary standards, systems, and infrastructure to support global-scale genomic knowledge sharing. A global need requires a global solution. I don't know why I have this. I don't know what happened. I don't know what happened. Screwed that one up. But anyways, the link doesn't work. A global need requires a global solution. Changes in our genome, both small and large. I'll leave the link. I'll find the link to this and I'll leave it in the show notes. Changes in our genome, both small and large, are a fact of life. They drive evolution, constantly introducing phenotype variability into the population, ensuring that we, as a species, can adapt to changing environments. However, this same process can also cause disease and illness. Yeah. The need for comprehensive global repository of genetic variation information that is freely and openly available has been recognized since the late 1980s. A number of groups have attempted to create such a repository in the past. However, none of these efforts has been successful, as they are all too locally oriented. They're too locally oriented and fail to engage broadly on the entire community, thus limiting both their sphere of influence and their ability, listen to this, and their ability to collect data from a significant portion of the world's population. Now, if only we had a pandemic that would mandate the testing of everybody, that we could actually confiscate the genetic material from that. Just saying. Not saying, just saying. You know what I'm saying? In 2006, all of these groups and a number of the world's top genetics clinicians and bioinformaticians, and representatives of the World Health Organization,
European Commission, United Nations Education, Science and Cultural Organization, March of Dimes Foundation, the Centers for Disease and Control Prevention, and some 24 international genetic bodies and numerous genetic journals met in a meeting in Melbourne, Australia. The delegates at these meetings recognized that only way to address the global need for information was via a global initiative.
Oh, might that be COVID?
This was the beginning of the Human Variome Project. No one organization or country can do this alone. As the United Nations Educational, Scientific, and Cultural Organization's 1997 Universal Declaration on the Human Genome and Human Rights remind us, I just showed you that document earlier, they quote, "The human genome underlies the fundamental utility of all members of the human family. The human genome is common to all humans, regardless of the country of origin, race, creed, or religion. The effects of the particular variant on the progressions of the disease in a patient in Australia is useful information to a patient with that same disease and that same variant in every other country in the world. This necessitates a global, coordinated response. The Human Genome Project acts as an umbrella organization, actively engaged with partners and stakeholders in each country to ensure that genetic variation information generated during routine diagnostic and predictive testing is collected and shared in the course of routine clinical practice, as well as provide opportunities for training, education, and capacity building." It's right there. It's right there. You don't think that when every single test, and in some cases, in many cases, college students and other people were being mandated through routine tests. All these COVID tests that they were giving out, all these free tests that they were giving out, and, PCR tests, all that genetic information that they were gathering, you don't think that that was being used? This Variome Project, the Human Variome Project, is what put together strategies to do exactly that on a global basis. I mean, what better to accomplish that than a pandemic of international concern, right? Lock everybody down and get them all tested, man. Get that genetic material. They want to codify that so that this information, the Human Variome Project, acts as an umbrella organization, actually engaging in partners and stakeholders in each country to ensure that genetic variation information generated during routine diagnostic and predictive testing is collected and shared in the course of routine clinical practice. Yeah. Yeah, I might have said Human Genome Project, but it's Human Variome Project. I wanted to throw that in there. How many people have even ever heard of the Human Variome Project? I don't know. Also, I wanted to put on here the Framework for Responsibility. See also a little bit more information on that Hugo Framework for Responsible Sharing of Genetic Health Data. The framework sets forth a harmonized and human rights approach to responsible data sharing. And the Human Genome Project, a challenge to human rights framework. Now, this paper I have found referenced on multiple papers going over and pushing the world socialism of human rights in on all of property rights in the assault on intellectual property rights. This is a Human Genome Project, a challenge to human rights framework. Now, there's nothing here. I can't find it. I can't get to it. Maybe you have to be signed in to get to it. There's nothing. There's no abstract. It just says no abstract available. I can't find the paper anywhere. But it's referenced and cited multiple times. So maybe if somebody can find it, you know. But anyways, I'm trying to see in here. The role of regarding Hugo. Let's see. I don't know. I'm not seeing it. Oh, maybe we'll get into it here in a minute. Maybe we'll get into it here in a minute. Sorry about this. I lost my spot. Here we are. Yeah. Hugo. The UN for Human Genome. International agreements and bodies that oversee them have taken a bit of a beating in the last few years. The current U.S. administration's unilateral approach to global problems has seen the demise of international community's effort against anthropogenic climate change. The selective adherence to international rules and trades, and the imposition of steel tariffs, the refusal to ratify the World Court, and more recently the invasion of Iraq. What the hell is the date on this? This is 2003. Does it sound like it sounds like today, doesn't it? 20 years ago, 20-something years ago. The establishment of Hugo was first suggested at 1988 Cold Springs Harbor meeting and emerged largely from the human chromosome mapping meetings that took place during the 1970s and 80s. A meeting in Switzerland later led to the establishment of an academy-like organizations with 220 elected members from 23 countries. A truly international, albeit exclusive organization coordinating collaborative research on the human genome. It would seem then that as the Human Genome Project evolved, Hugo went the way of other international organizations in the face of U.S. economic, scientific, and political might. Natural genetics highlighted the divide between Hugo, which comprised primarily human geneticists, and the genomics community in 1998. The members of the Hugo were interested primarily in medical genetics rather than wide biological importance of genomes. They were, internationalists. They were more, as a truly international organization, Hugo has been instrumental in reaching out to groups and nations that have not actively participated in the Human Genome Project. Following a recent circulations of its memberships, Hugo has recruited scientists from 24 countries to act as ambassadors for the genome community. These individuals will do outreach. And at the same time, Hugo needs to assert its role in the world that expectant of the fruits of the genome for the collective. Towards that end, Hugo should look at new means of enabling international research and building on the infrastructure that is in place. More than ever, the world needs a UN for the human genome. That organization should be Hugo. So I just wanted to show you how this world socialism, this world collectivism, Hugo being a prime aspect of the Human Genomes Project, right? I mean, who knew, right? With regard to the Human Genome Project, the team of scientists working on it, grouped in an organization known by the acronym HUGO, have expressed special concern that the project should be governed by biological principles. And here we go. And these are them principles. And then the Human Variome Project, which codifies the collection, curation, interpretation, and sharing of this genetic information into routine clinical practices and research. So every time you go to the doctor, literally, they could be collecting this genetic information for whatever, every time they take a blood test. You know? But anyways, so conclusion of this, get down to the conclusion of this aspect, and here we're back to WIPO's intellectual property and human rights. The conclusion on page 87 for this part. There is therefore an obligation on all human beings, and especially in this context on those engaged in the study of intellectual property, to give its human dimension to the disciplines that we are developing, duly mindful of the fact that intellectual property is not an end but a means to an end, and that ultimately what we all have to achieve is the development of mankind as a whole. So yeah, this is all just collectivist doctrine and world socialist doctrine here. Without discrimination of any kind, this being indeed the aim pursued by the Universal Declaration of Human Rights. Yes. The world socialism of human rights. Yeah. The human rights perspective on intellectual property, scientific progress, and access to the benefits of science. This comes from page 127 in that document. Intellectual property regimes, see what I'm saying? Intellectual property regimes seek to balance the moral and economic rights of creators and inventors with the wider interests and needs of society. There it is. Intellectual property regimes seek to balance the moral and economic rights of creators and inventors with the wider interests of needs of society. I don't know, this is kind of weird here because they're saying intellectual property regimes seek to balance. The intellectual property regimes must be looking at it from a world socialist perspective if what they're saying here is true. Just saying. A major justification for patents and copyrights is that the incentives and rewards to major justification for patents and copyrights is the incentives and rewards, to inventors results in the benefits for the society. The United States Constitution, written in 1787, for example, vests the Congress with the power to promote the progress of science and useful arts by securing. So actually here they use the actual word by securing, not by granting. For limited times to authors and inventors an exclusive right to their respectful writings and discoveries. 200 years later, the World Intellectual Property Organization, WIPO, links the existence of an equitable and modernized patent system to the incentives of the inventiveness and innovative activity, a willingness to invest in industrial applications, and a favorable climate to the transfer of technologies for the greater good of the collective, right? A human rights approach to intellectual property takes what is often an implicit balance between the rights of inventors and creators, and the individual rights of the individual, and the interests of the wider society within intellectual property paradigms, and makes it far more explicit and exacting, like I said before, so you can't wiggle out. Globalization is inimical to human rights. I think that's hostile, stands in the way of, Globalization is inimical to human rights considerations in a variety of ways. The first is the values orientations it promotes. A human rights approach is predicated on the centrality of protecting and nurturing human dignity in the common good. Human dignity in the world socialism of human rights, it's a false promise. It's the dignity, whatever dignity best benefits the collective, whatever dignity best benefits the needs of the planet. Just saying. Yeah, the needs of nurturing human dignity in the common good. It evaluates science according to its ability to promote these goals. In contrast, commercialization and privatization place greatest emphasis on profitability of science and its contributions to economic competitiveness. Free market capitalism is a competition. You actually have to have the best, most proficient, efficient product that there is out there, cost effective, and translates other values into economic or property discourse. Studies have shown that the conceptions of assuming underlying property discourse tend to influence and crowd out other modes of valuation. The presumption is that all other modes of valuation should be translated into market terms. Now, you might see all these different color codes on here. Probably think this guy's freaking nuts. But what these different colors in here, what I'm trying to do is they speak of intellectual property, rights of the inventors, rights of the individual, intellectual property. In green, I got commercialization, privatization, greatest emphasis on profitability. That kind of shit is all our founding principles, individual, free market enterprise, capitalism, and the engine of a free society. Property rights, okay? They're speaking of those things. When they're speaking of those things, I put it in green. So then in blue or red, I'm just pointing things out and highlighting what they're saying in here. But the blue, as a rule of thumb, what I'm pointing out is the collectivist doctrine perspective. Collectivist doctrine perspective I put in blue so you can see that. Globalization, I should have put that in green, is inimical to human rights. But see, that statement, globalization is inimical to human rights, is a collectivist doctrine as a whole. And that's what I'm trying to point out. It's mostly for me to be able to see where these different things through this are pointing out and how this part of that paragraph is speaking to these terms and this part of the paragraph is speaking to those terms. But it helps me clarify to you so that I can clarify to you as best I can, pointing out here what they're actually doing here, what they're actually, the world socialism of human rights, how they're rolling this into and codifying this into the structure of this UN document, so that you can see it. And I kind of do that through this whole thing on my other works too. I highlight it so that I can see it, and maybe you can too. I don't know. But if you see it in these terms, you'll be able to understand. It's like a human rights approach to intellectual property takes what is often an implicit balance between the rights of inventors and creators, the individual, and the interests of a wider society in blue with intellectual property paradigms. So I want to point out that they're calling paradigms. So if you're not in a world socialist paradigm, then you're in this capitalist globalization paradigm where property rights are interfering with the common good. And gray is just basically something else that I'm highlighting in there too. It continues the subject, and in the interest of a wider society within intellectual property paradigms, and makes it far more explicit and exacting. Right, so you can't wiggle out. Yeah. Yeah. Additionally, globalization encourages a reconceptualization of the role of the state, reducing its regulatory and redistributive functions and privatizing the performance of many services. Yeah, the role of the state is reduced But what they're doing here is globalization encourages a reconceptualization of the role of the state. No. It reconceptualizes it only from a world socialist perspective, from our founding principles perspective. This globalization that they're talking about, this spread of capitalism and free enterprise and, rugged individualism is our government, the limited government that we have, the constitutionally ordained limited powers of our limited constitution, that our limited constitution actually ordains government, are enumerated. It's not a reconceptualization. That's the original intent in our founding principles. But in the world socialism of human rights, in the world socialism of all this, from a communist perspective, which is a world collectivist perspective, this is what we're getting. It reconceptualizes from the perspective of the world socialism, it reconceptualizes the role of the state, reducing its regulatory and redistributive functions. See, it shouldn't have that power in our limited republic. It's bound from having that power. In privatizing the performance of many citizens. Well, the government wouldn't have the power to begin with in our founding republic. This is problematic for the realization of human rights. Yeah. Freedom, liberty, free market enterprise, and the pursuit of an independent happiness is problematic for the realization of human rights, because then all those human rights have to be understood in the context of the world socialism that doesn't recognize them. See what I'm saying? The recognition of rights confers reciprocal duties and obligations for the realization, and human rights law usually vests these responsibilities in the state. Yeah, the state's responsibility to enforce these human rights for the benefit of the collective. And enforcing these human rights for the benefit of the collective necessitates the compromise of the individual right. The rights of individuals are necessarily compromised in order to make that happen. And human rights law usually vests these responsibilities in the state. Yes, thus an ambitious human rights agenda, particularly in the relationship to the realization of economic, social, and cultural rights, requires a strong and effective state. That's why we don't have that's why we have a constitution that limits the powers of the state. And socialism requires a state that has strong and requires a strong and effective state. They're opposites. They're in contention. However, at the century's end, key elements of the welfare state model are being cast aside. They're complaining about that. And the resources invested in this is back in 98, remember, when, I don't know, it was the end of the Clinton era? Maybe? I don't know. And the resources invested in the state are being downsized. In this reorientation, they're calling it a reorientation, the state is increasingly viewed as a mechanism for establishing the conditions for private actors to fulfill their goals. This often comes at the expense of assuming direct responsibility for social welfare and the common good as defined by human rights norms. Yeah, they're in contention. In the process, they're not the same. Human rights norms are the exact opposite. They must destroy, human rights must destroy our natural individual rights in order to exist. Like I said, they're matter and antimatter. In the process, governments are becoming increasingly responsive to the influence of strong economic interests, capitalism, to the detriment and the effectiveness of institutions representing broader constituencies or the common good. This paper will deal with these issues. It is written in 3 major sections. This gives you an idea what's in here.
The first conceptualizes the scope and limitations of the proportions of Article 15 of the International Covenant on Economics and Social and Cultural Rights, which I've gone over before. It basically clarifies, from a perspective of World Socialist perspective, clarifies the common good necessity for any type of intellectual property. That the right to health or right to science will overrule in the balance of what the property rights in between the property rights of the individual and the needs of the collective. That balance, that slave word balance is in there. It's like a dialectic frickin' thing. You know, the truth is in the middle, the truth is in the middle, the truth is in the middle shit, right? Where it can never be obtained. Because if the truth is in the middle here and truth is in the middle here, then you create this, you put it in the middle here. Now the truth is in the middle there, and now the truth is in the middle between them, and it's an abyss. That truth can never be obtained. It makes truth unobtainable. It's an anti-truth. The Hegelian dialectical thing is an anti-truth concept. It's a progressive collectivist concept. It is an anti-truth concept. Oh, yeah. So, anyways. The second and third sections of the paper are in the form of case studies and two contested subjects, gene patenting and database protection. Both of these issues have attracted considerable attention in recent years since the Human Genome Project, right? They are also topics in which Directorate of Science and Policy Programs and the American Association for the Advancement of Science, the AAAS, has been involved. Now, again, they're implicated here. They are, in my last show, I went over how they're centralizing science and they're interjecting the world socialism, their they're agents of the world socialist revolution, socializing science, codifying this world socialism of human rights into science, the social hierarchy of science into our legal system. They're training our judges. They're training our legal system, our lawyers, in partnership with the Bar Association to train our judges and our lawyers in the tenets of world socialist revolution and how to see things in their courtroom and rule on things in their courtrooms according to the tenets of world socialist and the world revolution and the tenets of the world socialism of human rights. It's there. Where nothing can be held to strict scrutiny. The government can never be held to strict scrutiny in the world socialism of human rights. They can only be held to the rational basis test. And whatever is rational according to the needs of the planners. And who decides what that is? The planners. Now, this Article 15 of the International Covenant on Economic, Social, and Cultural Rights is constantly referred to in these doctrines. The Article 15 builds on the text of the parallel articles in the Universal Declaration of Human Rights. So, again, it builds on the parallel articles in Universal Declaration of Human Rights. In Article 27, where everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production for which he is the author. Not the owner, but the author. But this is the Declaration of Human Rights recognizing the rights of the individual, right? But also it says everyone. So this is where the conflict within human rights, within the human rights paradigm, within the human rights regime, the world socialism of human rights, that's the contention within that limited spectrum of debate, but it's all within the world socialism of human rights. Science and technology have played an important role in the war after World War II. Like other provisions in the Universal Declaration of Human Rights, the context for drafting Article 27 was the widespread reaction to the Nazi genocide and the brutality of World War II. Science and technology had played an important role in the war and served as an instrument of the Holocaust. Yes, it did. Therefore, it is not surprising that some eminent members of the scientific community took an active part of the public debate after the war regarding the development of a code of universal human rights norms. So they use the Nazis as an excuse to push the communism of human rights. They include Julian Huxley, a British biologist and writer who served as the first director of the United Nations Educational UNESCO, and the American chemist W.A. Noyes and J.M. Burgers, a member of the Royal Netherlands Academy of Science. I got a star asterisk here. These guys are three notable elites that were worked to internationalize or centralize science on a global scale post-World War I and World War II in the context of Comtean principles. That's a word they used. Comtean in the articles, which would include the hierarchy of sciences, aspect of anti-individual, thus no psychology, and anti-God religion of humanity. Comtean principles. Hey, P, come here. Hey, P's up. Come here, kid. What's up? There you go. A piece of food there. But anyways, you feeling all right, kid? Yeah. We're almost done. We're getting there. These guys. The centralization of science. I've been going over the centralization of science, kind of pointing out the centralization of science as a whole has been ongoing. And it really got kicked off, after, in between World War I and World War II, and then right after World War II, by these guys. They were called internationalists. But I've been reading on it, and I want to do a whole show on just that, but I'm not there yet. I'm not ready. But these guys are Huxley, Aldous Huxley, Julian Huxley, Noyes, not the same Noyes that was a transcendentalist with the Bible communism, not the same guy. As far as I could see. But there's a hierarchy of science that was established as Comtean principles. I kind of talked about it in my last show a little bit. In this article here, the dawning of a right to science and Universal Declaration of Human Rights. The right to science then was published in 2021. Of interest in that article, that's this article here. What's interesting in that article is footnote number 14 actually points to on the UNESCO's intellectual contribution to the drafting of the Universal Declaration of Human Rights. Okay? Now these guys up here we're talking about, therefore it is not surprising that some eminent members of the scientific community took an active part in the public debate after World War I in the development of the Code of Universal Human Rights Norms. And UNESCO played a part in drafting the original Universal Declaration of Human Rights. And there's footnote 14 in this article here, the dawning of a right. On the UNESCO's intellectual contribution to the drafting of the Universal Declaration of Human Rights, it says, see this article from 1948 with contributions from J. Meritain, I didn't have time to look into him. Mahatma Gandhi, that M. Gandhi is Mahatma Gandhi. E.H. Carr, who is a unorthodox socialist. They refer to him as an unorthodox or a heterodox socialist. And a technocratic functionalist bent towards utilizing the centralized prowess of not only communist Russia, but Hitler's Nazis and nationalism, and Mussolini's fascist nationalism for global common good, taking those things and bending them towards use for a global common good. Yeah. And B. Croce, who was a liberal humanist, and R.P. Teilhard de Chardin. These are the guys that are involved in this.
Chardin's involved in this. Aldous Huxley, in 2 specific papers on scientific matters, rights and duties concerning creative expression, in particular in science, by J.M. Burgers, and Science and the Rights of Man by W.A. Noyes. See, this is the article that points to. These are the guys that were involved in the centralization of science, or also involved in drafting the Universal Declaration of Human Rights. It's not a coincidence. It's not a coincidence. I just want to point that out. Also, see the nuclei in a supersaturated solution. This article kind of goes into the centralization of science and how these guys all got together post World War I, and to bring all these things together. I don't know what just happened there, but anyway, in that article, that's that article there. In that article, they have the after recollecting a statement by Cohen, is the guy who put this together, about the unique and impressive Dutch Nobel Prize ratio, Noyes prophesized about a peaceful future. All 3 lectures that they pointed, they gave, a bunch of these guys gave lectures in this meeting of these guys, right? These internationalists. All 3 lectures grounded their optimism in Comtean ideals of science. I just wanted to point that out. What Comtean, I'm not making this shit up. Comtean, when I see Comtean ideals of science, there's a lot to that. His religion of humanity, the evolution of society through phases away from religions and a belief in God towards a religion of humanity, and the eventual evolution of human society towards the final end of a single global human organism, ruled by one queen or central table of planners. That's why all the sciences in the world, there's a hierarchy of science that becomes established by Comte in what he coined as sociology. It's the same sociology being taught today. When you see sociologists, when you see credentials as a sociologist from a guy, this is a guy or a person that is been put through the dip of Auguste Comte's visualization of the eventual end of a single global human organism to whatever extent. This is the same sociology that is today. They can deny it all they want. Sociology doesn't recognize psychology because psychology is for the individual, right? Well, why worrying about the psychology of an individual when we should be concentrating on the sociology of the humanity as a whole? The individual isn't even recognized by Auguste Comte's sociology, or his positivism, or whatever you want to refer to it as. The smallest group being the family. And God, the whole concept of God or a belief in God is given way, and humanity becomes the great being and all sorts of morality. These are just things that I go over in my book. Last Call for Liberty, I went over these things. I think it's in chapter 2. Not sure, can't remember. But anyways, I wrote that book 10 years ago. Published it 10 years ago. But it's got all these basic fundamental things of all this collectivism that once you come to learn, and you learn about these different collectivist doctrines of different perspectives of different collectivist doctrines, anarchist, communist, nationalist, humanist, they're all the same collectivism. They all have a common thread, multiple common threads. They're all the same collectivism, And once you can recognize these things, you can see it wherever it is. And that's why I wrote the book for my kids, so that they would have a trusted source from me, that they would be able to learn the tenets of collectivist revolution and learn also the tenets of our founding principles and where they contend, and how that collectivism has targeted our founding principles and individual rights and liberty for destruction, and the means by which they're doing it, and also ways in which they're hiding that they're actually doing it. They're not always going to do it in your face. They're going to disguise disguise their assault on our individual rights and liberty and founding principles. One of the ways they're doing it is with human rights. But the whole of science has been captured by this. The whole of science as it exists today, it has been captured, has been socialized by these Comtean ideals for the same objective of that final end of humanity as a single global human organism. And here you have the hierarchy of sciences. You know, you got physics at the bottom, chemistry, biology, neuroscience, psychology. I don't even know why they don't even recognize psychology in there, but generally in some cases, in some doctrine, they don't even recognize psychology because that's just for the freaking individual. It's quack science. But social science is the humanities. Sociology is the queen of all sciences, so that you can take all these things right down here. Whatever is learned in here can be funneled down through, the planners can funnel it down through sociology and decipher what aspects of it can be best used for the utilization of promoting the progress of human society away from individualism towards that final end of a single global human organism. Okay.
Breaking news. The number one cause of heart attacks and strokes isn't hypertension. It isn't cholesterol. Too much red meat.
And independency of other departments. Comte classified knowledge based on observation of science, scientific or positive level of human thinking. The main aim of the classification of science by Comte is to prepare the background and basis for the study of society. Sociology is science invented by him. And this also he determined the methodology of sociology. Increasing complexity, decreasing generality.
Do we need to hear any more of that? See what it is. Hierarchy of science. The socialization of science. All science is socialized. Conceptualizing science within a human rights framework. Okay. We're back to the original article here that I'm going down through. This one. Conceptualizing science within a human rights framework, however, required more than just insulating science and technology from potential misuse or even protecting the public from exposing the harmful effects of science. Like the language and other provisions of the Universal Declaration of Human Rights, Article 27 recognizes a series of rights or claims. All of these rights, including those related to science and culture, are considered to be universal. Universal meaning they're for the collective. Human rights articulated in the Universal Declaration of Human Rights are also held to exist independently of recognition or implementation in the customs or legal systems of the particular countries. Human rights are held to comprise important norms that create prima facie obligations, particularly on the part of governments, to take positive measures to protect and uphold these rights, whether they recognize them or not. It's right there. The Universal Declaration of Human Rights was adopted unanimously by the General Assembly December 10, 1948. As a General Assembly action, the Universal Declaration of Human Rights is inspirational or advisory in nature. It does not, here's the thing I was telling you about earlier too, it does not legally bind member states of the UN to implement it. Over time, however, the Universal Declaration of Human Rights has gradually assumed the status of customary international law. It is considered to be the single most authoritative source of human rights norms. Nevertheless, the ICESL SCR, the International Covenant on Economic, Social, and Cultural Rights, and the ICCR, the International Covenant on Civil and Political Rights, along with the Universal Declaration of Human Rights, are said to constitute the Universal Bill of Human Rights, which we just went over, okay? Together, they set the minimal standards of decent social and governmental practice. I got this International Covenant on Economic, Social, and Cultural Rights. Yeah, the ICC. This is what they want you to know. If it's on Wiki, this is what they want you to know. This is what the planner. This is the main frame narrative. Is WikiLeaks. If it's on here, this is what they want you to know. So it's kind of interesting to go there for that reason. The ICESCR has its roots in the same process that led to the Universal Declaration of Human Rights. And this International Covenant on Civil and Political Rights, the ICCPR, International Covenant on Civil and Political Rights, is considered a seminal document in the history of international law and human rights, forming part of the International Bill of Human Rights, along with the International Covenant on Economic, Social, and Cultural Rights, and the Universal Declaration of Human Rights. And it's monitored through the United Nations Human Rights Committee. So, what is on Wiki is consistent from this 1998, and it's still on Wiki today. The same shit, right? Together, they set the minimal standards of decent social and governmental practice. The language in Article 15 of the ICESCR, builds on, but also differs from the Universal Declaration of Human Rights in a number of ways. Much like the Universal Declaration, the first paragraph recognizes three rights: the right of everyone to partake in cultural life, to enjoy the benefits of science and progress and its applications, to benefit from the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. So, best benefits the collective. It is relevant to note that the intellectual property provision in the Universal Declaration of Human Rights was carried over to the ICSCR, which, despite the fact that the article on the right to property was not, despite the fact that the article on the right to property was not, the ICESCR has no equivalent to the Universal Declaration's Article 17 language that everyone has the right to own property alone, as well as in association with others. Nor does it make the commitment found in Article 17(2) that no one shall be arbitrarily deprived of their property. Most notably, because the ICESCR has the status of a treaty, and as such is legally binding on those nations that become state parties. The text of Article 15 in the ICESCR articulates a series of responsibilities for state parties that are absent from the Universal Declaration. Articulates a series of responsibilities for state parties that are absent from the Universal Declaration. It uses the format of steps to be taken. In doing so, the ICESCR translates aspirational language of the Universal Declaration into specific legal obligations. Yeah, Universal Declaration of Human Rights. But it has been put together with other international agreements that have the specification or legal classification as treaties. In doing so, the ISU translates the aspirational language of the Universal Declaration into specific legal obligations. Together, they form a legal compact, from what they're saying. The inception of the Human Genome Project, okay. In 1988, a major international initiative to decode the human genome accelerated the pace of genetic discoveries and raises anew the issues related to commercialization of biology. It has been described as a single most important project in biology and medical sciences. June 1991, well before any of the significant issues regarding intellectual property rights and or applications of the research and discoveries funded through the Human Genome Project were thoroughly debated, let alone resolved, NIH decided to file a patent application on 350 gene fragments that had been identified by one of its scientists. The NIH decided to file a patent application. The government agency filed the patent agents. It was government agencies filing for patents that created the controversy, and this got the ball rolling in the world socialist assault on our property rights through the assault on intellectual property rights, patents. People, us, the little guys, the average Joes, people, family businesses, subject to market forces, exposed and subject to market forces. We had nothing to do with it was all government funded organization, government funded projects, government government agencies filing for the patent rights that actually got the ball rolling and gave justification to the world socialism of the world socialist revolution that's targeted all of our property rights and all of our individual rights and liberties for destruction. Gave them the Human Genome Project, and the government filing patents justified the global governance of a full-out assault on all of our private property rights via an assault on intellectual property rights. Here, P. You want to say hey, kid? Anyways, I'm almost done here, kid. Just wanted to point that out. Despite strong internal opposition to patenting, specifically by James Watson, the Nobel laureate, then serving as the director of the Human Genomes Project, NIH followed with a second patent application in February 1992, this time on an additional 2,375 gene fragments, and it later submitted a third application for another 4,000. This is the NIH. The U.S. Patent Office turned down the initial NIH patent application on the grounds that the gene fragments were neither novel nor useful in themselves. It also found that NIH's proposed inventions obvious. NIH did not appeal the decision, and subsequently a new director issued a statement advocating that its grantees desist from seeking patents on human gene sequences. Writing in Science magazine, that's the AAAS magazine, right? In May 1998, John Dole, the director of the U.S. Patent Office, I think that USPTO, section that handles biotechnological patents, sought to provide a clarification in his policy and on the patenting of DNA. Two of the points that he made are particularly important. To respond to criticisms that the Patent Office accepted patents on discoveries of naturally occurring sequences in organisms. To respond to the criticisms that they accepted patents on discoveries of naturally occurring sequences in organisms, Dahl distinguished between naturally occurring DNA sequences and sequences that are isolated and purified. According to Dahl, the former still does not qualify for patents under U.S. law. However, if a patent application states that the DNA sequences in question are isolated, which means that they're synthetic and different from the natural, well, if they're different from the natural, legally different from the natural, then being able to get a patent on, how are we then to understand that the virology created from the synthetic isolation, we're still to believe that that's the natural virus that's going to pandemic around the world? Meanwhile, the sequence in the mud puddle or the cave goes nowhere. So there's a difference. There is a specified difference here between the synthetic artificial virology in the lab and the actual RNA or DNA sequences in nature. But we're led to believe that they're one and the same when it comes to, viruses or other pathogens or indemnicity. Fumbling my words, but anyways, we're led to believe it's all the same. Yet here there's specified difference when it comes to patents. Just throwing it out there for your consideration. They distinguished between naturally occurring DNA sequences and the sequences. They distinguished between naturally occurring DNA sequences and sequences that are isolated and purified. According to Dahl, the former still does not qualify for patents under U.S. law. However, if a patent application states that the DNA sequences in question are isolated and purified, manufacturers or compositions of matter or part of a recombinant molecule or part of a vector, it would meet the requirement of being distinguished for its natural state and constitute patentable subject matter. And you want to know why all these people like Malone are patent, all of a sudden, specialists on international patent law or intellectual property rights specialists? A lot of these people involved in this are all of a sudden international property rights specialists. Dr. David Martin, intellectual property rights specialist. All these people pushing the world socialism of human rights or anti-capitalist tenets of the world socialism, like Malone, with his pushing the world socialism of basically Naomi Klein. Anti-Marxist socialism of Naomi Klein, as did Dr. James Thorpe, who was, in partnership with McCullough and the Wellness Company, right? Malhotra, pushing the same world socialism. But anyways, the whole intellectual property rights expert regime kind of goes hand in hand with all this shit. You kind of get an idea why or how that comes into play here, because they got to know, well, if they're going to isolate, well, how do you isolate shit? How do you isolate shit? Right? Ask Dr. Jonathan Cooey. It's all, this is what they call virology. The virology, the fake virology, or synthetic, I should say, virology is patentable. They can make money on that shit. No sense in having a wild virus that's actually, or a wild pathogen out there, because they can't make money on that, right? I don't know. They can't patent it anyway. The second source of opposition related to the anticipated negative effects that patenting would have on research and therapeutic application of knowledge generated by the Human Genome Project. 1991 statement on patenting of DNA sequences issued by the Human Genome Organization, HUGO, the international research consortium coordinating and enhancing efforts in genome research, reflects these concerns. Most of the public support and excitement of the Human Genome Project and other genetic research have generated derives from the promise it holds from the diagnosis and eventual development of therapies to treat genetic abnormalities. Human gene therapy have been described as a symbol of hope in a vast sea of human suffering due to heredity. Look at all the mistakes God made, right? Thus, for the development of gene therapies has been stymied by difficulties in identifying suitable and effective vectors through which to deliver correct genes to the right locations in the cell, but the future privatization of control over genes may be an increasingly important factor. Many genetic disorders affect relatively small numbers of people, anywhere from a handful to a few thousand people, hardly an inviting commercial prospect. As one gene therapist noted, the whole concept of gene therapy for genetic disease doesn't fit the business model. It is therefore not surprising that the focus of gene therapy has shifted from inherited diseases toward other more common and potentially profitable ailments like cancer, AIDS, and heart disease. Of the 244 gene therapy trials authorized by NIH since 1989, only 3 are for diseases caused by a defect in a single gene, and half of those were of cystic fibrosis, the most common inherited disease among Caucasians. A lot can be taken out of that there. Right? Doesn't fit the business model. Only Caucasians. They're doing research on only stuff that affects Caucasians. A lot could be freaking brought out of that. Shared database plays a particular important role in large, complex, interdisciplinary, collaborative scientific efforts such as the Human Genome Project, global climate modeling, and AIDS research. Widespread international dissemination of data is key to fostering and maintaining linkages with a global scientific community, with a centralized science. Conclusion. A fundamental thesis of this paper is that human rights approach to intellectual property takes what is often an implicit balance. This is repeating the same shit, but then just kind of brings it all to a point here. Between the rights of inventors and creators and the interests of a wider society within the intellectual property paradigms, and makes it far more explicit and exacting. To be consistent with the norms of the ICESCR, a human rights approach requires that the type and level of protection afforded under any intellectual property regime directly facilitates and promotes scientific progress and its implications, and so in a manner that it will broadly benefit the members of society on an individual, corporate, and international level. You have to have a hierarchy of science to do that, to socialize it. It also implies a right of access to the benefits of science, again, to both an individual and collective level. Additional components are a right to protection from a potential harmful effects of scientific and technological developments, and a right of choice in determining priorities and making major decisions. There's your right of choice. Your right to choose. Again, I've showed this before. This right to choose that the medical freedom movement is out there espousing, that the CHD is out there espousing, MAGA, whatever, the Phoenix, whatever, all of leftist progressivism even. This whole right of choice is wholly within the context of the world socialism of human rights. It's from within the confines, the right to choose within the confines of human rights. It's not a free choice. It's only a choice between the things that they're given you to choose from. These two case studies examined in this paper, genetic patenting and database protections, underscore the additional difficulties exposed by dynamics of economic globalization, the spread of capitalism, and respecting and fulfilling these principles. In both cases, a traditional goal and rationale of intellectual property regimes to provide incentives, reward to innovators, researchers, and authors have been replaced by a new emphasis on the protection of investments They want to protect their investment. Simultaneously, commercialization and privatization accelerated by globalization, by the spread of capitalism, America spreading that capitalism, are affecting the very conduct and nature of science. Yeah, because they want to socialize science via the tenets of world socialism. And the globalization, the spread of capitalism is going to fight against that to some degree. Free enterprise. These tend to have negative implications for the promotion of scientific progress and access to its benefits if you're defining science from the perspective of world socialism or world socialist revolution. Now, just to wrap this up, I wanted to kind of show, remembering the Apollo project, I came across some things, and I'm going to be getting into some other things in the next few shows. They got this, the Apollo project. Now, the Human Genomes Project was big, one of the biggest projects out there in the history, right, of science and the history of whatever. If you go down here and you look at this, I got this chart here. It came out of one of these articles. The Apollo project promises to dwarf any and everything, including the Human Genomes Project. And you got the Human Genomes Project here, and you can see they're down here. The budget was $3 billion, which is it's $6 billion today, over $6 billion today. This Apollo program, they're looking at $100 billion. They're looking at $100 billion that they want to invest in it. And the kind of, go back here, I got this article right here. The White House wants $65 billion for the Apollo-style pandemic preparedness program. Okay. Which they want to, and I'm going to be getting into this for my next couple of shows, maybe kind of dive into this a little bit, but I kind of wanted to show you what they're going after here. And they're going after this, they're building this on Trump's policies on warp speed. They're building it off of warp speed. They're calling for $65 billion to do it, but actually they're shooting for $100 billion. In this paper here, this comes from 2024. Biden was asking for $65 billion in 2021. So this is Yeah, there's warp speed right there. They got $12 billion, double what the Human Genome Project was. But Apollo Project is going to dwarf them all. It's going to dwarf them all. It's going to dwarf them all. Yeah, by investing in research and development at home and providing resources and international public-private partnerships, the United States could provide leadership in coordinating globally while also enabling the nation's talent to lead scientifically. Operation Warp Speed demonstrated that the new approaches in vaccine developed, such as mRNA platform technology, can drastically shorten the timeline from decades to months. Operation Warp Speed has generated significant momentum for vaccine development capability that should continue beyond the COVID-19 pandemic to prevent the next. I just kind of wanted to show you that and the whole context of that. And this chart came from page 61 to 64 or somewhere in there, just to give you an idea. What we're looking at: Panama Canal, the Manhattan Project, National Highway System. Where that they blame for white flight out of the neighborhoods, right? The Lunar Program, the Apollo Program, Smallpox Eradication Program, Global Positioning Systems, an International Space Station, all the different... Anyways, it just gives you an idea. It just gives you an idea what we're up against, what they're after, where they're coming from and doing it. And I wanted to tie that in for you. I hope you got something out of the show today. America is under assault. America is under attack. Our founding principles are under attack. Our liberty is under attack. And from a liberty perspective, I want to show you these things so that you can take them into consideration. So you can, if not our sake. I mean, it's complicated. Come here, kid. Come here. I know. Mini Pete is just about had it with all this stuff. What do you think? Huh? Yeah, no. You don't like it. No, she don't like it at all. Nope. Anyways, I'm Joe Marshall. Thanks for stopping by. I hope you got something out of it, and I look forward to seeing you at the next Liberty Perspective.